All right, so today's lecture is going to be on discrimination. I wanted to talk a little bit about how we define discrimination, because it seemed like there was some confusion about this on Thursday. Now, normally, we refer to discrimination, when you all think of discrimination, as a bad thing. And a lot of the times, discrimination is a bad thing. It can be a very bad thing. But it's not always a bad thing. I think you all need to, at least for this unit, get into the habit of thinking of discrimination as just kind of a neutral term that refers to distinguishing among people based on some characteristic. Okay? Do folks understand what I'm saying here? It's distinguishing among people based on some characteristic, right? So we're going to get into this with more detail, but I want us to begin to kind of rethink discrimination as it's been taught to you, okay? So here's an example of bad discrimination. Not just bad, but illegal, unconstitutional discrimination, right? And this is what we talked about last week, right? Mr. Dunbar gave you the history of the 14th Amendment prior to Brown. I talked about what happened after Brown, right? But we know now that racial segregation, right, when it comes to public facilities like water fountains, is unconstitutional. It's illegal, and generally, even if it wasn't, we would think of this as being a bad form of discrimination, right? So this is a classic example of discrimination, racial segregation, which is bad and illegal. But the question I want to talk about today is all discrimination unconstitutional, and is all discrimination bad? Okay? I want us to kind of, again, we're gonna revisit the way that you all have been taught discrimination to kind of try and understand discrimination in a more nuanced way, right? When does discrimination become bad? When does discrimination become problematic? Right? So just to kind of illustrate the point that not all discrimination is bad or illegal, I want to just go through a couple of examples, right? So Mr. Dunbar has alluded to this in the past, right? But tax brackets, right? You know, in this country, right, depending on what your income is, how much money you bring in, you get taxed at a different rate, okay? It's a progressive tax system, and this is a classic form of discrimination. It's not racial discrimination, right? It's income discrimination, right? But we can see here, right, if you make more than, you know, I think it's around $50,000, right? You go from paying I guess around a 15% tax rate up to about a, I guess 25% tax rate, right? So you guys get how this works, right? The more money you make, the larger chunk of taxes that you have to pay. That is classic discrimination, right? It's distinguishing among people based on some characteristic. In this case, that characteristic is income, and this is perfectly legal. It's perfectly legal, and I think most people here are okay with it. Do folks have a problem with the staggered tax rate?
Wait, what? That whole big line, but why does it go so highly like that?
You talking about the red line or the blue line?
The blue line, at the end of the blue line.
At the end of the
people who make a lot of money investing,
yeah,
they don't go up that much. As much as
right, no, it's a great point, right? So the difference between 33 and then I think the next rate is 36, or maybe it's 35, it's not that much, right? But the idea is that once you've crossed over into that, it looks like $350,000 income bracket, it does go up a couple of percent, right? So we're still distinguishing, right? We're still discriminating, right? Okay. So this is a form of legal discrimination, and one that it seems like none of you at least have voiced any opposition to, right? Here's another form of discrimination, right? I do this all the time. Grades, right? It's performance discrimination, right? You all may have noticed on end grade, some of you don't turn in your homework with the regularity with which me and Mr. Dunbar would like, and your grade suffers as a result. That's discrimination, right? We're discriminating based on how often you turn in your homework. We're discriminating on how you perform on your quizzes, right? We don't really think of that as discrimination because we, again, you all have been conditioned to think of discrimination as racial discrimination or these other forms of discrimination, but this is still discrimination, right? It is distinguishing among people based on some characteristic. In this case, that characteristic is performance, right? Okay. We'll just go through one more example, right? Height discrimination. We talked a little bit about this on Thursday, right? But anytime you go to like the county fair and it has one of these signs, right? You must be at least this tall to ride. That's height discrimination, right? We know that there are safety reasons for this, but it's still discrimination, right? It's keeping people out based on their height, right? So the idea is, there are some forms of discrimination that you see every day that you don't even bother thinking twice about, right? They're perfectly fine. You never would think they're illegal. You never would even think that they're bad, right? The question that we're going to be focusing on today, once again, right, is how do we know when discrimination is bad? And specifically, because this is a constitutional law class, how do we know when discrimination is unconstitutional? Okay? And we began to answer this question on Thursday when we talked about those 3 levels of scrutiny. I want us to now get into those levels of scrutiny in a little bit more detail. So remember we talked about, right, where do the 3 levels of scrutiny come from? Well, they basically come from the test that we use to determine whether or not something has violated the Equal Protection Clause, right? So this was kind of, we asked this question, well, here's what the text of the Equal Protection Clause says, right? How do we get from that text into these actual decisions, right? How do we get from that, no state shall deny to any person within its jurisdiction equal protection of the laws? How do we get from that language into, integrated schools? How do we get from that language into striking down anti-miscegenation laws, right? How do we get from that language into all the decisions that you will have been studying and will continue to study in this unit, right? And again, we know it's these 3 levels of scrutiny, right? And you all became very good on Thursday at kind of figuring out when these levels of scrutiny apply to different kinds of discrimination, right? So, the answers are up on the board, but what kind of test would we apply to a law that discriminates based on race? Strict scrutiny, right? What kind of test would a court apply to a law that discriminates based on sex or gender? Intermediate scrutiny, right? And what kind of test would a court apply to, a law that discriminates based on age? Rational basis, right? So we have this kind of step ladder, these tiers of scrutiny, okay? And remember, it's the court that's doing the scrutinizing here, right? And again, we talked about this a little bit on Tuesday, right? But we know that rational basis is the easiest test to satisfy, right? It's not hard to get over the rational basis test, right? Intermediate scrutiny is pretty hard, and strict scrutiny is very hard. I don't know why this happened, but this actually says very hard, right? So the idea is that strict scrutiny is the hardest test to get over, and we're going to talk about why that is right now. Here's another way of thinking about it, though, right? If these people, right, are discriminatory laws, right, these tests are the size of the hurdles that they need to get over. Does that make sense to folks?
How did you make those?
With a lot of time. I'm glad you appreciate it, TT. All right, cool. So let's get into what does strict scrutiny mean, right? So you remember on Thursday we talked about kind of identifying the government's interest, right? What is the state's interest, right? You all know what that means, right? It's basically what is the government's reason for enacting this law, right? So the reason I wanted you all to be able to identify that quickly is because we need to know what the government's interest is in these cases in order to apply the strict scrutiny test, okay? So just a quick review. When do we apply the strict scrutiny test?
When it's based on race.
When what's based on race? You're right, but what? Discrimination, right? The discriminatory law, right? Because this is what courts are going to use. Remember, in this class, we're deciding whether laws are constitutional or not. Henry's absolutely right. When the law discriminates based on race, we're going to apply strict scrutiny to see if that law is constitutional. So, the first requirement in order to pass strict scrutiny, the law must have a compelling government interest, right? The government, in enacting the law, must have a very, very, very good reason, okay? So we talked a little bit about this on Thursday when we did our group work, right? But the idea here is that the government has to have a compelling interest. This is the language that I want you all to kind of memorize, right? The government must have a compelling interest in enacting a law that discriminates based on race. And not just that, but that discrimination must be narrowly tailored. What does narrowly tailored mean? What do folks think? We haven't talked about this explicitly yet, but we've kind of danced around it. What do folks think narrowly tailored means?
Like something involving how far they go to prove their interest. Good, right? It's kind of like how extreme is the government's action in achieving its goal, right? So if we think of the government's interest as its goal, then tailoring is kind of the means of its achieving that goal, right? So when we talked a little bit about this hypothetical, which I stole from a real case, right, involving the Connecticut Military Institute, the real case happened in Virginia, we'll talk about it in a couple of weeks, right? But when we talked about this, do you guys remember this CMI, right? This was the military institute, the state military institute that was discriminating against women, right? Said that women couldn't attend. What did we say? The government's interest there was fitness, right? They said women couldn't achieve the level of fitness necessary to go through the rigorous training, right? And what was people's reaction to that? Amber had a good reaction. What was the reaction, Amber?
Some women can do what the guys do, and some men can't do what the guys do or whatever.
Perfect, right? Right. The law wasn't narrowly tailored, right? This is what we're talking about now, for exactly the reason that Amber just identified, which is that the law would have excluded some women who were capable of, the physical fitness, the rigorous physical fitness that the Military Institute required. And not just that, it would have let in some guys who were not capable, right? So if the government's interest, right, was making sure that everybody who comes to the school is able to achieve that level of physical fitness, then what should they have done instead of having this pure gender test?
Well, to get in.
Right, what would that test look like in the beginning?
Just a physical examination.
Exactly, right? It would be like kind of a physical fitness test, right? That way we would ensure anyone who passes the physical fitness test is physically fit, anyone who fails is not. That's a much more narrowly tailored way of achieving their goal, right? Which is making sure everyone who comes in is physically fit, than simply segregating by gender. This is kind of a hard point. I want to make sure folks are getting this. So are folks understanding narrow tailoring? Right. It means that the government has to do its best to really achieve that interest without using sex, right? Or without using race or whatever it is, right? If the government can do the same thing without using that characteristic, it should, okay? And its failure to do so is unconstitutional. Does that make sense? We'll keep getting into this, right? So that's at one end of the spectrum, right? Strict scrutiny is the hardest, right? It's the biggest hurdle, right? Rational basis is at the other end. It's the easiest, right? It's a very small hurdle. It's easy to get over. So the idea here is if there's any reason whatsoever, right? Doesn't even have to be a good reason. You can identify any reason whatsoever for the discrimination, right? It's okay. It's constitutional, right? And remember, this only applies to, those things that we kind of, I shouldn't say only, but this generally applies only to those things that we think of as being everyday discrimination, acceptable discrimination anyway, right? If someone wanted to challenge my grading in this class, right? Grading based on performance, right? That would be rational basis, right? It's not based on race. It's not based on... No, okay. It's not based on race. It's not based on sex or gender, right? It would be a rational basis, right? And my reason would be, well, colleges want to know how you performed in class. I'm going to grade you based on performance. That's the norm. That's what everyone does. All of this, right? I think we might actually be good because we're only going with a few more minutes, so let's go. Yeah. Right. So rational basis, very, very easy. Strict scrutiny, very, very hard. What about if we're in the middle? What if we're at intermediate scrutiny, right? This is also very hard. It's called intermediate scrutiny, but I want you all to think of this as being much closer to strict scrutiny than it is to rational basis. Does that make sense? It's only slightly easier than strict scrutiny. And basically, the idea here is the government has to have an important interest, and it needs to be reasonably tailored. Okay? So do you folks remember what the language for strict scrutiny was?
No.
Compelling interest, right? And in the magical world of constitutional law and the magical world of federal courts, there's a difference between compelling and important. In the real world, these both mean you have to have a good reason, right? But here we're going to distinguish, right? An important interest and reasonably tailored. So maybe not quite narrowly tailored, but reasonably tailored. All right? Reasonably tailored, narrowly tailored, again, these mean almost the same thing, right? The way I want to think of this, right? The government has to have a good reason, and it has to try and achieve that reason. It has to try and achieve its goal in as narrowly tailored a way as possible, right? It has to use the best means it can, and has to try not to use race or sex or gender, right? Does that make sense to folks? I know this is hard. We're going to get into this a little bit more throughout the next few classes, but I really want to just introduce what these different tests are. And you're going to need to know these different tests and apply them on your test, on your quiz next week, right? So here's how I want us to think about these things, right? We have our equal protection machine, okay? And here's what we do, right? We have entry pipes, and we have exit pipes. And what we do every time we see a discriminatory law is we go to this machine, okay? This is how I want you all to begin to think of it until you've really internalized this fully, right? So we take our discriminatory law, and the first question we ask ourselves is which entry pipe do we put it into? Are we going to apply strict scrutiny? Are we going to apply intermediate scrutiny? Are we going to apply rational basis review? You all, I think, are pretty good at this already because we did this on Thursday, right? So how do we know which entry pipe to use? Montrell? Right, so my question is, how do we know which entry pipe we're going to use? I was asking because you were on the computer. I thought maybe you were looking for the answer. Okay, no, okay, all right. So then let's try this again, right? So which entry pipe are we going to use, right? We have a discriminatory law. Someone has challenged that law and says that violates equal protection. And now we need to decide which entry pipe we're going to put it in the equal protection machine. And that's going to help us determine which exit pipe it comes out of. Right? So we have a discriminatory law. Which test are we going to apply to that law? How do we know which test we apply?
So we answer like which test or just say?
I want you to tell me how we know which test to apply. Okay, all right. Help from co-counsel. Nicole.
Well, if the discrimination is against race, it goes into strict scrutiny.
Perfect.
If it's against gender or sex, it's intermediate, and if it's any other, it's rational basis.
Perfect. So basically, the way that we determine the entry pipe is the kind of discrimination that's going on, right? Does that make sense to folks? What type of discrimination? What is the basis for the discrimination? That's how we're going to determine what entry pipe it goes in. So, okay, so say, we've got these different laws, right? We decide the entry pipe. It's going to go into the equal protection machine, and that's going to be basically, we apply these different tests, right? And depending on how those different tests come out, that's how we're going to know whether it's constitutional or not constitutional, right? Let's do an example. Good. So, a state passes a new driver's license law that contains the following provisions. The following provisions means following sections. So this law has different sections, right? Can I have someone read section A? Leah.
The state will only issue driver's license to people over...
I'm sorry, that should be older than 17 years of age.
17 years of age.
Okay, good, right? So people get this first one?
Yeah.
Section A, right? You have to be 17 to get a driver's license. Montreal, can you read section B?
The state will rescind the driver's license of any pregnant women who is caught driving without a seatbelt.
Okay, do folks know this word rescind?
Take away or something, right?
Good, right? Take away, right? The state will take away the driver's license of any pregnant woman who's caught driving without a seatbelt. Okay, good. And Terrence, can you read the third section, section C?
The state will not issue driver's license to any person who identifies as Latin American or Latino.
Good. Okay, right. So we understand the three sections. We'll go back to these, but let's go through and apply our this equal protection machine to the driver's license law. And we're going to take this in sections, right? Because the different sections are doing different things, right? So what about, just to remember, what is section A? We think it's going in the rational pipe, and I think you're right. Good. And if we put things in the rational pipe, they almost always come out constitutional, right? So what is the rational basis test? Do folks remember?
Just need a good reason.
You need a good reason. Or actually, do you need a good reason?
Just for
Any reason.
Any reason, right, Montreal? Good, exactly, right? Any reason. So what would the reason in this case be for the state, if you had to find one? Remember, any reason will do, right?
Age.
Right, age is how they're discriminating, but why would they do that? Why would they discriminate based on age?
Because anybody can't drive.
Right, to limit who's allowed to drive. Why is age a good base of discriminating? Why not
Safety.
safety? Good, so say a little bit more. Safety. Why is safety? How does age relate to safety?
Because someone younger may not be equipped to the road as someone older.
Good, right? So for various reasons, right? Maybe someone is more mature, right? When they're a little bit older, we want to make sure that we have drivers on the road who know what they're doing. They might be a little bit more intelligent, right? We don't want to be giving driver's licenses to every 3-year-old that wants one, right? Good. So discriminating on age, there's a rational basis for it. There's a reason, right? That's really what rational basis means. Is there a reason? And we know there's a reason, right? So section A, constitutional. What about section B? Do folks remember section B? Section B is the one that dealt with taking away licenses from pregnant women who were caught driving without a seatbelt. What kind of discrimination is that? This is a little bit tricky. And now we have a little bit of a debate. This is good. Okay. So some people shout out rational basis. Some people shout out intermediate. Let me hear from someone who shouted out rational basis why they think rational basis. Carly, you were one of the rational basis people, no?
Because it's dealing with the fact that she's pregnant.
Pregnancy, okay. And can I hear from someone who shouted out intermediate?
Since she's pregnant, they're worrying about the safety of the child inside her. Like, she was to get into an accident. Also, the controversy with wearing seatbelts and cars.
Okay, that's true, but why'd you say intermediate scrutiny? Besides the fact that I accidentally put it up on the board prematurely and you all know the answer.
I went on gender.
Good.
Since it said pregnant women specifically.
Good, right? So, yeah, Robert.
I went on weight.
You went on weight.
Right?
Okay, but is the actual discrimination based on weight? This is important.
But it's her baby. That's why, like.
No, but guys can get pregnant, so it doesn't matter.
Okay, before we get into that, before we get into
But
biology
it's like you
here.
can't. It's like wearing a seatbelt probably hurts her or like the baby.
Okay, right. That may be fine. That may be the reason, right? That may be one of the state's reasons. But what is the actual kind of discrimination?
Gender.
Gender. Specifically, pregnancy, right? Pregnancy, right? This law only applies to pregnant women. It doesn't apply to non-pregnant women. Does it apply to pregnant men? Let's look at the language.
Yes.
Let's look at the language. Any pregnant woman, right? So let's, even if we forget the fact that, right, that men can't get pregnant, right? that it still only applies to pregnant women, right? You should also just think, right, because men can't get pregnant, this is basically discrimination against women, right? This is a tricky one, right? In fact, this is so tricky that Congress, several years ago, actually enacted a law called the Pregnancy Discrimination Act, where they said, we're going to treat discrimination on the basis of pregnancy the same as we treat discrimination on the basis of gender, right? So they basically said, if you're going to discriminate against someone based on pregnancy, we're going to look at that for the purposes of like employment discrimination and other laws. We're going to treat that like gender discrimination, right? And if we're in the gender discrimination world, what test do we apply? Intermediate, right? Good. So this was a tricky one. I put it in there deliberately, and you know, this is, I actually don't know about this, but I went out on a limb and said unconstitutional. All right? Because what would the government, and how would we apply the intermediate scrutiny test? What would that be? What would that look like? What is intermediate scrutiny? What was the test again? Okay, good. So right. So reasonably tailored was one aspect of it. What was the other aspect of it? The first part. Good. Right. Important interest. Right. Were you about to say compelling?
Yeah.
So compelling is strict scrutiny, right? I know it's kind of a tough distinction, but that's good, right? I mean, you guys are getting the important parts, right? The government's interest is a part, and then the tailoring is a part. In this case, an important interest, right? Good. Okay. So in this case, I said I didn't think that the government's interest was so important as to justify, you know, the actual discrimination that's going on here. They're taking away the driver's license, right? There might be other ways of achieving this kind of. If the government's goal is to protect unborn children, right, there might be a different way of achieving this than discriminating against pregnant women, right? But it's a closer call than the other one, right? Rational basis is always very easy, right? It's, do you have a reason, right? Intermediate scrutiny is a little bit trickier, right? What about, okay. So this is why I need to get a better mastery of kind of PowerPoint, because I think I'm just giving you the answer, but do folks remember section C? What does section C say? What does section C? What kind of discrimination is going on in section C? Race, right? Race, basically. So, if it's race discrimination, what kind of test are we going to apply? Let's all pretend like we haven't just seen the answer. Strict. Robert. You're being facetious. Maybe? Okay, we're going to go on and say you're being facetious, right? So strict, right? Marshall shouted this out, other folks shouted this out, right? This is correct, right? Strict scrutiny is what we apply to racial discrimination, and in this case, I've said, I think it comes out unconstitutional, right? What is the government's reason, if we had to find one, right? What is the government's reason for restricting driver's licenses to people who are not Latinos? They don't really provide a reason in the law, right? And it'd be hard to even think of a reason, right?
Because they can't communicate to get pulled over.
But it didn't say, right? But let's actually be very careful about our comments here, right? This is actually a fairly sensitive subject, and you know, this is not actually the kind of discrimination that's going on, right? They're not saying if you don't speak the language, right? I mean, there's some people in this country. I mean, you may have been joking around, Robert, but this is actually a hotly debated issue: whether we're going to give driver's licenses to people who are undocumented immigrants, right? Now, that's not the same as racial discrimination, but it's motivated a lot of times by.
Is that like
wait,
driver's insurance?
I thought if you weren't.
It's not quite. I mean, it sort of has to be an insurance issue. But what was your point?
It's not got to be a resident in the state to get a driver's license.
Right. So that's another kind of discrimination, right? But remember, I mean, there are. I mean, I'm kind of nervous about where you're going with this, but like, there are plenty of Latino and Latinas that live in Connecticut, right? They're residents of this state.
No, but you said they were undocumented.
Right, so that's a separate thing, right? That's a separate. I was saying the reason I was bringing that up is because this is that is a hotly debated issue, and it was it's based somewhat on some of the ideas that you were bringing up, right? But the idea is, right, there are still Latin American citizens of this country, right, who speak English, right? I mean, even if they were discriminating on the basis of language, we could question whether or not that's really acceptable. But that's not even what this law is doing, right? This law is so much further into. It's clearly just based on race, right? It doesn't say anything about language. It's simply if you are of Latin American descent, they won't give you a driver's license, right? It's very hard to come up with a reason for that.
Just saying that they said he was African American, we can't get.
Right. This resembles, right, Montreal's bringing up a good point, right? This resembles the Jim Crow South, this law, right? This is not a real law, by the way. I want to communicate that. I'm doing this so that we can learn how to apply the test, right? But you can now see why the tests work the way they do, right? It's very difficult to come up with a reason to discriminate on the basis of race, right? It's hard to come up with a good reason, right? And that's why strict scrutiny almost always results in unconstitutional ruling. Does that make sense to folks? It's hard to find a reason. It was hard to find any reason at all, let alone a compelling reason, right? A compelling interest, right? I know this is tricky. We're going to keep doing this, though. I just want to make sure that you guys are really sorting out these different tests, right? So remember, it's kind of like this spectrum that we have, right? Rational basis applies to most classifications, most kinds of discrimination. It's very easy to satisfy. Intermediate scrutiny is a little bit harder. Sex and gender. Strict scrutiny is very hard. Yeah, DT.
I have a question on something. Affirmative action is supposed to be a strict scrutiny, right? But affirmative action, I think it only applies to Latino and African American people. But like
False.
Right?
Well, Mr. Dunbar is giving you a one-word, unnuanced answer, but this is going to be the subject of tomorrow's class.
Yeah.
How we treat affirmative action. All right, and this is actually what I want us to talk about now. I want us to get into a discussion now. So we have another 15 minutes or so. First I want to take questions on the different levels of scrutiny on the actual doctrine itself. Do folks have questions about this? Yeah, Henry.
Do the levels of scrutiny sort of intertwine and make it difficult to form a real decision on how they would rule, how they would,
I'm not sure I do. So just say a little bit more.
Like, how do courts handle cases where the levels of scrutiny intertwine with each other and makes it difficult to form how they would rule out what to do with the case?
Cool. So give me an example. Are you talking about examples where the discrimination might be based on both sex and race, right? Okay, good. So that's a tough call, right? Because what the court would probably have to do in that situation is kind of sort out where the discrimination is happening, right? So in the law that we just had, right, that was one law, but it had these different sections that did different kinds of discrimination, and we were able to pick it apart, right? Separate them out and kind of take them one by one. Now, there might be a law that discriminates on both always. So it says this law only applies to, say, black women, okay? And that would be both sex and race. And in that case, they would probably go with the higher scrutiny, right? Because as long as race is a part of it, it's going to get strict scrutiny. As long as race is a part of it, it's going to get strict scrutiny. Does that make sense? As long as sex is a part of it, it will get intermediate scrutiny. It's a good question, though, right? Because there are actually plenty of laws where these things do intersect. It's actually, there are legal scholars who speak specifically about what's called intersectionality, which is what happens when discrimination happens along these different lines, right? Good. That's good. Do folks have other questions about the levels of scrutiny, about the law itself?
Henry, another point on that is occasionally, occasionally the court will see a category they've never seen before. A case that's totally new, and they have to sort of make a decision about where to put it in. And there isn't a law on the issue. The Constitution's not clear on the issue. This gets back to that discussion we had a couple of weeks ago about sort of what judges do and how judges make decisions. And the truth is, they sort of analogize. They're like, is this more like race or is this more like height? And then they make a judgment, and that's sort of the power the judges have. So one of the good examples that I think we've talked about in this case before is homosexuality versus heterosexuality. Where was that going to be put? And so today it's actually, it's not clear exactly where it is right now. It hasn't got to the Supreme Court yet. So, well, it has a couple times, but they said a couple different things.
Right. So actually, I don't want us to get into this, and I've just deliberately left off sexual orientation from here because it's a little bit more complicated, and we're going to actually spend an entire class on it in a couple of weeks.
Yep.
But basically, this is the way that you want to kind of think about this, right? What Mr. Dunbar is saying is that when new classifications, when new forms of discrimination come to the court, they're going to try and think, right, where do we want to put it on this spectrum? Yeah, Robert.
Say you were like on an airplane, right? And say, like I was on a plane that wasn't American.
Okay.
And like we left off American thing, but the aircraft is from it's owned by another country. Okay. So like you got in the air and you were off American soil, and what if they told you like they split the sections up differently, like on color or race?
Okay, this is
it's a civil procedure question.
Yeah, this is a rough question. Okay, so this is actually a question that doesn't just apply to race discrimination, right? We can say this question applies to all kinds of the Constitution, right? Basically, what your question is saying, right, is how far does the Constitution go, right? So, for instance, right, we could say this about free speech too, right? If the government of China, let's say, right, wants to restrict your speech, you're on a plane, you get there, you want to maybe wear a tuxedo or something like this, right? Andrews B. Belding, right? Right. If you want to engage in some kind of free speech act, the government wants to restrict that. Are you protected by the First Amendment? That's kind of the same question, right? In the same way they want to discriminate against you because you're black, let's say, are you protected by the 14th Amendment, right? These are all basically the same question, and they have to do with how far does the Constitution extend beyond our borders And as Mr. Dunbar said, this is a question that lawyers think of as a civil procedure question. It's not quite, I guess it is a constitutional law question because it's how far it goes, but it's not quite pertinent to this lecture, and it's got some complicated.
Robert, I guess a really quick answer would be, one, we have treaties with other countries to kind of establish that thing, and two, if you're operating a business, in your specific example, if you're operating a business in the United States, usually you have to set up sort of a corporation here, then you could sue that corporate entity in the United States based on the U.S. laws. But if you're in if you're like, I mean, airplanes are kind of special, like if you're actually in the air, but if you're actually in the other country, then it's more difficult.
Right.
It's more
I mean,
difficult to sue them.
We can talk about, you coming out to school today to work on the court? We can talk more about it then. But for now, let's kind of try and stick to the 3 levels of scrutiny in this. It's a great question. I don't want to dismiss it, but I mean, you could hear just from the beginning of Mr. Dunbar's answer that this has a kind of a complicated requirement.
If you really want to know, you should go to law school. That's sort of the answer.
All right, but other questions on this before we really kind of get into more of a discussion about these levels of scrutiny?
And not Yale Law School. Just joking. Because we suck at civil procedure.
so just if we can focus here for a second. Do folks have other questions on this? This is important. I want you all to know these levels of scrutiny. I want you to know what they are. I want you to know the differences between them.
So scrutiny doesn't matter about the reasons. It matters about the classification.
Okay. Good. So this, you know what would be helpful here? Let's go back to the machine, right? Good, right? Let's go back to right. So Robert just said, do the reasons matter when we're talking about levels of scrutiny, right? And here's the answer, right? The reasons matter once after we've decided which pipe it goes in, right? The reasons, right? The government's reasons matter because these tests, right, are all about the government's reasons, right? But the first question, which pipe does it go into, right? That reason matters less, right? Because basically we want to see kind of what is the basis of discrimination, right? And this is really before we really start to think hard about the reasons, right? It's a fairly complicated question because if the government says, right, well, we're creating this law. So for instance, right, the government might have a law that looks race neutral, right? A law that doesn't actually mention race at all. But the government's reason might be it wants to exclude people of a certain race from doing something. Can folks think of an example of this? A race-neutral law designed, let's say, to exclude Latinos, or let's say to exclude African Americans, or
darker color can go tanning.
Okay, but that's you're talking about color there, right? In order to say the darker colors can't go tanning, right, you actually have to mention color. You're basically getting at race, right? You're right. I mean, maybe it's not exactly race. Maybe it's about skin tone, right? But I think, right, one that's more familiar to us, right, would be. And by the way, I'm not saying that you're not taking this seriously, Robert. But this is actually a very, very this is a very, very serious issue, right? It's hotly debated, right? People spend their entire lives wrestling with this question, and not just that, but people have spent and devoted their entire lives to kind of trying to change these laws. So I don't want us to take this lightly. But right, let's take another example that we should not take lightly. Let's say poll taxes, or let's say grandfather clauses, right? Grandfather clauses, right? Do you folks remember these, right? These would have been in the post-Reconstruction South, right? After the Civil War, right? In order to keep African Americans from voting, many southern states passed laws that said, you can vote, you have the right to vote if your grandfather had the right to vote. Okay? Now, effectively, if you are living in, let's say, 1890, right? And if you're African American, more than likely your grandfather was a slave who didn't have the right to vote.
Wait, so you couldn't vote for like 50 years then? Or your grandkid can vote?
So, I mean, it's a complicated issue, right? It wasn't designed to ask these questions. It was designed to keep black people out of the polls. All right? So the idea is, right, if your grandfather couldn't vote, you can't vote. Now, that looks race neutral, right? It looks, right, it doesn't actually say anything about race. It's about grandparents, right? It's about kind of your family, right? But we know that in practice, that was meant to keep people out of the polls, to keep black people out of the polls, right? A law like that might be subject to strict scrutiny, right? I mean, courts have gotten kind of funny about this, right? But generally, right, to answer Robert's original question, right, does the reason matter when you're deciding which pipe it goes into? Generally, no. Reason comes in later. Reason comes in after we've decided the pipe, right? Because once we've decided on the pipe, we need to know how good is that reason. How good does that reason need to be in order to be constitutional, right? So how good does that reason need to be if we're in strict scrutiny land? Compelling. Good. How good does that reason need to be if we're in intermediate scrutiny land? important, right? And someone other than Henry for this last one, how good does that reason need to be if we're in rational basis review? Simple. Is that what you said?
I said reasonable.
Reasonable. Okay, I think it's even less than reasonable. It could even be unreasonable. It just has to be any kind of reason, right? Reasonable might be a good way of thinking about it, because that's what courts are looking for, right? But I think it's really, we got to think this is really easy to clear, right? People disagree about what's reasonable. This idea is basically pretty much anything. Yeah, DT, you had a question.
Oh yeah, I was gonna say something. There's like a case I read on the news, or we talked about it in school. In Hawaii, if your ancestors, depending on what tribe they're from or something, then if you could vote for, I think, a city, not the whole state.
Mm-hmm.
Wow, that's fascinating. So this is actually a case from 2000. It's called Rice v. Cayetano, I think, and it's not actually about cities. It's about being able to participate in elections that I think have to do with Hawaii has a state agency that deals with kind of native indigenous culture. And the idea is if you want to kind of participate in some of those decisions, I think, I'm not quite remembering this case fully because it was a while ago that I read it, but that's what it has to do with, right? That is, I mean, it's amazing that you've even heard of this case because it's such
I was like 12 in some grade.
I think you would have been even younger. I mean, maybe there was another case that came up after the big case. I think that deals with this.
Oh, yeah, it's called Rice something, but I guess my teacher talked about it after.
Wow. Yeah, so that would have been around 2000, I think.
He was Hawaiian. He played ukulele.
Oh, okay, all right. I mean, it's really incredible that you brought it. This is such a unique case. The only reason that I know it is because I'm a voting rights nerd. This is not considered kind of one of the canonical major cases, but it's a good question and it's very unique, right? So the idea of how would we evaluate that law, right? Hawaii, let's say, is a law that says you need to be of indigenous descent, or you need to have kind of indigenous ancestry. I think the way they say it is like something like 4 generations in Hawaii is the way the law was actually structured in order to participate in elections that have to do with this Bureau of Indigenous. I don't even know what it is. I'm probably getting it wrong.
Right?
What? It'd be strict, right? And how would it come out? How do we think it would come out? What is the strict scrutiny test?
Wrong. Come out wrong.
It would come out, well, let's stick to instead of right and wrong, right, constitutional, unconstitutional. I think it came out constitutional. I might have that wrong.
It should have been the other way.
Okay, and why? Why do you think so?
Because I don't think they have a really good reason.
So what is their reason? Let's get into that. What is their reason? Let's identify that.
Because maybe they think Hawaiian people, only if they've been in Hawaii a long time, makes them smarter, something like that.
Okay, but remember, they're only dealing with this one issue that has to deal with.
Okay, so the issue was a guy, you had to have generations, your family had to be from Hawaii for a long time to vote.
Right.
An election.
Well, no, not quite, right? It has to do with only elections relating to... So this isn't like elections for governor, this isn't elections for congressman, this is only elections for...
Oh, to be in a committee?
I think it has to do with this state agency, that only deals with kind of... It's like the agency for indigenous culture or something like this. Do you know this case, Rice v. Cayetano?
No.
Yeah. DT brought up a case which is really kind of random and very unique.
You brought up the case?
I guess you're saying you're a teacher that knew this case. It's very impressive that you know this case. I just want to say. I'll tell you what I'll do though. I'll go back and I'll look this up because I've read this case.
It's fine.
No, it's an important issue, right? But what are you saying though in terms of how do you think this comes out? You said the government's reason.
Oh no, I changed my mind. It's constitutional. No, because I thought that you were talking about a mayoral election, but if it's just a small group that has to deal with that, I think it's okay.
Then why do you think it's okay? Let's get to part 2 of the test. What is part 2 of the strict scrutiny test? What is it? Good reason is part 1. What's part 2?
It does what it needs to do.
Does what it needs to do. What's the word that you use for that?
Tailored.
Tailored, right? And why is this law more tailored than, right? I think this is the reason why you changed your mind, right? We're talking before, you said if it was elections for anything, right? That doesn't make sense, right? Because then we're discriminating against people based on
It's
their...
about the people who need to, the group, right? It has to do with indigenous something.
Right.
So it makes sense if the people who can vote were also
Right, because they've tailored the law, right?
Yes, so.
Yeah, I might be giving you wrong information. For all I know, that law
Yeah,
was
it's
struck
the
down.
Board of Trustees of the Office of Hawaiian Affairs.
There we go.
So,
The Board of Trustees of the Office of Hawaiian
I
Affairs.
mean, that's not exactly Congressman's.
Right, exactly, right? So it's a very narrow thing.
Henry's applauding.
What?
So Henry's applauding
Yeah,
your efforts.
there we go. I think Henry's applauding because we're 2 minutes away from the bell, or less. Why do folks think we have these different levels of scrutiny? Why do they break down in the way that they do?
Because they're trying to prepare for future complications with actual cases that can come into the law system.
Good, exactly, right? So it has to do with they're trying to kind of come up with a test that they can apply in the future. But why do it this way? Why not make race rational basis? We'll hang on that, right? What were you going to say?
So John Roberts
Race is sensitive.